This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking on who's on first, why insurers get into a dispute about who must defend an additional insured when they have differing other insurance clauses that control who defends whom. The Travelers Indemnity Company of America and Defendant Ohio Security Insurance Company moved for summary judgment in Travelers versus Ohio Security, a May 10, 2024 decision of the United States District Court for the Southern District of New York. Ohio Security issued an insurance policy to Sutega USA Corp. Travelers sued, seeking a declaratory judgment that under the policy, Ohio Security had a duty to defend and indemnify Shawmut Design and Construction and others in a state court action. The construction contracts involved between Zara, Shawmut, and Sutega entered into several contracts related to construction of a new Zara store in Palisades, New York. The contract stated that Shawmut shall supervise and direct all the work, and all parties included additional insured provisions and other insurance provisions so that everybody was covered. The traveler's policy provided commercial general liability coverage subject to certain terms, conditions, and exclusions. The traveler's policy also contained an amendment to its other insurance provisions stating that, quote, this insurance is excess over any of the other insurance, whether primary, excess, contingent, or any other basis that is available as the insured when the insured is added as an additional insured under any policy, including umbrella or excess policies, close quote. The traveler's policy provided coverage for Zara, Eklecco, and Pyramid as additional insured subject to certain terms and conditions. Ohio Security issued a commercial general liability policy to Sutega. The Ohio Security policy applied Sutega's place of business is listed as an address in Miami, Florida, and is relevant here. The policy states that Ohio Security has the right and duty to defend the insured against any suit seeking damages for bodily injury. The policy contained a commercial general liability extension endorsement that defines insured to include any person or organization whom you have agreed to add as an additional insured in a written contract. The Ohio policy also contains an additional other insurance provision. John Osterlich was injured while using a table saw during the construction. Osterlich sued just about everybody, including Shawmut, in New York State Court. Osterlich alleged that the defendants breached their non-delegable duties under New York law to maintain a safe work environment where he shouldn't have been hurt. Shawmut's insurer, Travelers, alleged that Sutega's insurer, Ohio Security, has a duty to defend and indemnify Shawmut, Zara, Eklecco, and Pyramid in the state court action, and Ohio Security denied that its policy covered those entities. The only disputed issue for the court at this time was whether Shawmut is covered by the Ohio Security policy. The answer is yes, at least as to Ohio Security's duty to defend Shawmut. For purposes of these motions, the court found that no actual conflict existed. The only disputed issue is whether the Ohio Security policy covered Shawmut. Under both Florida and New York law, an insurer's duty to defend is broad. The parties do not dispute there is a written contract between Sutega and Shawmut. Therefore, Ohio Security has a duty to defend Shawmut in the underlying state court action pursuant to the policy issued to Sutega. Shawmut as an additional insured under the Ohio Security policy in the underlying state court litigation, and neither party disputed that Shawmut also had insurance coverage as the named insured under the Travelers policy. The Travelers argued that Ohio Security is required to provide coverage on a primary and non-contributory basis and the traveler's policy was excess, given the plain language of the insurance contracts and Ohio Securities' failure to respond. The court agreed with travelers. In my opinion, other insurance clauses in insurance policies often result in unnecessary disputes between insurers as to who, between multiple insurers who insure against the same risk of loss, must be first in line to defend or indemnify the insured. The court resolved one of those disputes in this case and told the various insurers and insureds to resolve the remaining disputes, considering its ruling. To answer the question as to Shawmut, Ohio is on first. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,800 blog postings. Please tell your friends and colleagues about the blog and videos and let them subscribe. It's free. And if you're interested in further detail about insurance, insurance law, insurance fraud, or insurance claims, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.